Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, is holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for I apologize. Oh, it's on level 2. It needs we're cutting it. I'm not doing it again. I'm not. I'm not going to spend all day reading the comments about how the internet sucks or how much I talk. So I will creed frame here while I pull up the video. I always do. Don't worry. This one doesn't count. But I swear to fucking God, 2 more times, I'm calling it. I'm not in the fucking mood. That one was to be expected. It didn't count. Technically, I think that one counted, but we'll give it a fucking minute.
Can you hear me?
Yes. I'm going live here, so let me just.
I was gonna explain, I woke up today and the one Coke that I put in the fridge that I
The
saved.
37th Circuit
Oh,
Court
shut
is now in session.
You know what?
with the
Her fucking annoying voice needs to shut up for a second. I'll refresh. Oh, it's doing it again. It's a trifecta. Anyways, oh. My whole point is the fresh first sip. The best one. The one I wait for all day. I'll just hit play.
Monday, July 1st.
Before the court on the plan. I think this motion for child support and Ms. Pace now.
I'm shook at that anybody's still here. It says 27. I don't fucking believe it. It's my voice that triggers it. Apparently my image is fine. If we want to just stare at me being sullen. Hi, Sean. Hi, guys. Also, want to add some insult to injury here. I got an ad earlier today for the best internet in Canada. Guess what? Already have it. It's frustrating. And then there it goes. Oh, well, I did add a computer to my Amazon wish list. It's $10. That's super cheap. I wish I could afford it if right now, because then we wouldn't have this. But you work for put a really cute red dress on there. That polka dotted red dress. I won't ever forget. So beautiful. I want it so This was an actual grift, like, it was there. The router's right there. The fucking there. I threw my glasses. It did hit something and the screen apologized. It's back now. A terrible episode. Mm. I didn't poof that time. I took myself off the screen on purpose, preemptively. Hi, MB. How are you? Having a terrible night so far. Still holding better numbers than some nights. Let's keep that in mind. I just restarted the computer, Bev. I restarted the computer. I actually think that this is a StreamYard problem because we didn't have problems yesterday, did we, guys? Did we have problems the day before? No. We, it's, it's, I think if I restart, it'll actually fuck the stream. Although I don't know why. It is hosted on a cloud that I pay for. I guess I could do a router reset, but that would be a long time. I don't want to have to do that. Ed, we've run diagnosis on the computer too. Anyways, Navars, I used to use Streamlabs, which is why there's still a Streamlabs bot in here. But there's things. You gifted one? Did I miss it? I'm a terrible man. A terrible person, Tom. I'm not a man. I was gonna say I'm a terrible man. Thank you. It does seem to be now working, but as soon as I say that, it's like a jinx. It's a jinx. It's me jinxing it. Thank you so much, Tom. See, I haven't added anything for us to watch and we're okay. But as soon as I add in what we have to watch, it's the problem. And I'm telling you that I'm not streaming those files off the internet for all of you who are like, well, lady, maybe you shouldn't try and show YouTube on your stream. It's not that. These are videos that are on the computer. They're fully downloaded. They fucking should not be lagging. And we ran diagnostics on the computer, and it's not actually that terrible of a computer. It appears to be a this time of night StreamYard issue. But maybe I got cut off before when I was so flagrantly pitching my Amazon wish list, explaining that I put a mini computer on there for 350 Canadian dollars, and Jim H coming through with 5 memberships. What? How do I get my annoying voice? 5? I sound like that kid that was on the TV interview. I don't know. I've never been on TV before. Jim, thank you so much. Honestly, this has been a membership mayhem month, and I love it. And I am so thankful for you. So yeah. The cops are coming. Oh, can you hear the sirens? Yes. That's a constant where I live. It's I actually just drown them completely out. I don't even listen to them because they're a constant. What's new though is that the dog that I'm dog sitting this month howls if they come down this street. So that's really exciting. Should we try and put the video on again or what? Oh, I'm not in a hood actually. That's the funny thing. I just live near the hospital. And I also live near the emergency I only know this because I used to work there, but basically the emergency response center for all the police, fire, ambulance, 911 center is down the street from where I live and in a place where I used to work. And so there's a constant stream of uh, emergency vehicles around on the street, which is a thoroughfare. And it also means that our power very rarely goes out because they put it back on real quick around here because it is, again, the emergency control center. That's back when I used to work as what was my title? Emergency management assistant. I can make up my title now. I can have any title I want now. I've had some amazing job titles. That would be a fun members only to do. Just list off all the different jobs I've had. And yeah, exactly. The worst neighborhood, the worst, quote unquote, and I say it like that seriously. The worst neighborhood in my town is called Pandora Street. It runs very far, so it's really only 2 blocks that are really bad, but it's rampant open drug use, crime, people sleeping in tents. Like it's if you see the videos of like Kensington or the Vancouver downtown east side, it's very similar, just in a smaller scale. But I still walk down that street by myself because I'm not really afraid of homeless people or drug addicts. They're really just people and they don't frighten me any more than anybody else. So, but that would be the worst area to walk down, and I'm far from it. Millions and millions of dollar homes around here just because of the land value. Humble brag. Anyways, okay, let's try and add a video. If you haven't been here in a while, what a great night to show up. My something's fucking up. It was so good. Oh, a raid. Perfect. 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 I'll just entertain. If everybody could come on in, push forward, please. Everybody's arriving from Collins. I'm going to need everybody to come on forward. Get to the front of the room, please. Everybody coming from Collins, say hello. Make sure that you clock in for your shift and hit that like button. Also, make sure to tell us what you've had for dinner tonight. If you didn't like what you had for dinner, go ahead and tell us what you wish you had for dinner. Seriously, guys, move forward. Seriously, we got like 95 people in here now. We got to move to the forward, push on forward. Seriously, hi guys, welcome. I hope everybody's having a wonderful evening. We are about to start watching some court. I don't know what I didn't eat yet. That's why I'm asking about dinner. And Miss Heather, oh, you want pizza or you wish you had pizza? I like that. Heather, how's your internet? Because mine sucks. I'll say that. Anyways, if you're new here, welcome. I am Kitchen Court Chats. We chat in my kitchen. We used to. Anyways, actually, my name is Paisley, and we do watch a lot of court. We also have a lot of fun. We talk about lots of things. Hi, Presto. Ooh, and I really do love to hear what everyone has for dinner because I never know what to eat, and I live on the west coast of Canada, and so it's only 6:45, which for me is a bit early. I like to pretend like I'm Italian. I'm not, but you know, in Italy they eat real late. Spain, the same thing. You had Taco Bell. We don't have Taco Bell where I live, but I'm in it. I'm for it. Anthony, should I try and say where you're from? Chincoteague? That sounds terrible pronunciation. Hi, Debbie. Oh, riced cauliflower fried rice. Sounds like you're trying to sell us something. I'm just joking. I am with you, Lori. I haven't eaten yet either, like I said. And I am glad. I know, like that's me too, MB. It's just the way it is. Um, so if you are new here, gonna try and put something on, but things have been, I don't want to jinx it. Like we just had some internet issues, but let me just give a moment. Was that good? I love it. Love it, love it, love it. Anyways, I'm gonna freeze frame while I put this up. Don't worry, I'll be right back. And then we're gonna watch Court together. She held her breath, praying to God, baby Jesus, the Canadian internet moose. Let's try this again.
Can you hear me?
Never
Yes.
ever.
I'm going live, Paris. Let me just.
Internet
37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2023-2780 DP, Taylor Coyer versus Jalen.
pays no. I was like, wait, that name's familiar. That's what's her face here from St. Jacob. He's a pro football player? Really? Why can't it just fucking work? That's what I want to know. I got to go off green for it to work better. Let's just gods. Also,
Of the defendant, this matters this motion for child support. I have read all the pleadings in this matter. It does appear based upon me to have an evidentiary hearing to decide the ultimate issue, a number of issues that has to decide in this matter. You have to add.
thank you so much. Oh, I don't believe. I can't believe it. Thank you, thank you, thank you. Make sure that you've turned gifting on. Hey! Gosh, darn it. Oh! Good getting us started. All right, well, we're in it for the long haul now. I better
ask if this court could.
Your thoughts?
Yes, thank you, Your Honor. I have reached out to Ms. Pacino. We have been working well together in my judgment. And I did suggest that a sum of $2,000 per month be granted presently pending your review and or the friend of the court's review, because as the court may be aware, if Mr. Naylor had paid anything, it could have been determined voluntary payment. And so I'm happy to enter an order at this time at $2,000 per month if it's within the court's discretion to do that at this time, adjusted either upward or downward, depending on how you decide or how the friend of the court might rule.
Okay. Well, the court does note, at least Mr. Scott in his answer says at one point the parties had agreed to the $2,000 per month. I don't know if that's the case, and I don't know if the proofs will establish that, but at this point, the court will order the sum of $2,000 per month commencing on today's date, July 1 each month thereafter, subject to obviously modification as we proceed. And the court will schedule an evidentiary hearing to determine all the issues that we have to arrive at the correct support amount. Anything else, Ms. Payson?
Nothing further, Your Honor.
Mr. Scott?
I have nothing further, Your Honor.
Okay. Ms. Payson, if you would submit that order under 7 day, we will conclude and then we'll be in touch with you. Is there anything else you need to do, Ms. Payson and Mr. Scott, before we have an evidentiary hearing? Because I want to make sure if there's any discovery or anything you're doing that we don't schedule it before that.
We may need to have a brief deposition, Your Honor, just on some of the issues, but it would be not a great deal of time is necessary, probably 30 to 45 days at the most.
Okay. Ms. Payson?
Attorney Scott and I have been working well together, transferring information as needed. So it's be appropriate.
Okay. What we'll do is we'll probably set it sometime later August. If that works into everybody's schedules, and we'll be in touch with you to see what works with your schedules and your clients as well. And then we will have a hearing. I don't think the hearing would take more than a couple hours, so we'll schedule it at that point.
Just a point of clarification. My client is in Minnesota. Is it okay with the court to do that via Zoom?
Yes.
Thank you.
Okay. Thank you. You're free to go. Have a good day.
All right,
Thank you,
thank you, Your Honor.
Thanks, Jayla.
Thank you.
See you, bud.
Did he now? Oh, let's see. Oh, we'll see how good we do. Almost $1 million a year salary. Well, then 2K a month. No problem. Oh, I did, ma'am. I'm trying my camera now. I'm really hoping it works.
Please unmute.
I said I did. Duh.
Good morning.
Good morning.
Caitlin Carr.
Yes,
Okay, and what case are you appearing for this morning?
I'm here on behalf of the Polaris versus Evolution.
Okay, and you are here representing
On behalf of plaintiff.
Benjamin.
Yeah, Ben Sobchak is also going to be appearing.
All right, I'll place you in the waiting room.
Thank you.
Thank you. Please unmute.
So Sheena, just do the dark triad test. Although they don't recommend that you share your results with people. If you're interested in what I'm talking about, I'm referring to something in the chat. But the dark triad test rates your 3 levels of psychopathy, narcissism, and
All right.
Machiavellianism.
Huntsman, you are here on Hercules, Bradbury.
Cheryl's back from Bullies. Was it amazing, Cheryl? Tell us all about it. Understand, though, that the dark triad test is ranked against criminals. So it is.
Calling case 2024.
Hold on. Just keep that in mind. So the average sample was from criminals. So grain of salt.
549 CB Hercules Material Holdings versus Schaefer Ready Mix Incorporated et al. Today,
The appearance of Mr. Bradbury on behalf of the plaintiff. Ms. Hansma on behalf of a defendant as well. This matter is before the court on various issues in this particular case. Defendant, you can proceed. I've read all of the pleading. You don't need to reiterate that if you just want to respond to, again, this answer, and then we can proceed.
Certainly, I appreciate that, Your Honor, and I trust that you did have a chance to look at all of that. I think it's important in context to understand that my client, Schaefer Ready Mix, is in this case as a defendant because the plaintiff has asserted 2 tort actions against my client, interference with contract and interference with business expectancy. And so, as you might imagine, defending those claims requires that we understand what specific acts they believe that Schaefer engaged in that would give rise to liability. And so when we prepared these discovery requests, the thrust of them is to figure out what specifically is it you're alleging we did here? And what we're seeing is kind of the classic, well, we know you did something wrong, but we won't know what it is until you tell us. And so where I am in discovery is,
so your client's not willing to tell them?
Well, my client says we didn't do anything wrong, as you might imagine. So that's kind of where it's turned into this chicken or the egg situation, but they're the plaintiff.
Okay.
And so if they're saying that, Schaefer, you have our confidential and non-public information, which is actually a term of art they use in their complaint, and you used it to interfere with our contracts and our customers, I say back, explain to me, obviously you don't have to put your trade secrets in court filings, but explain the nature of the information you're claiming we have and how we used it, when and with whom. So this is your complaint, your allegation, and then I get back an objection saying none of that is relevant. And so, and that's the nature of the responses I got to each of my requests. A lot of times it's, well, discovery is not over yet. And as you might recall, Your Honor, discovery was over before you extended it this past week. And so here we are at the end of discovery, and I'm asking, tell us specifically what actions Schaefer took. By way of example, they'll say in their complaint that you went out and you solicited Wallbridge, by way of example, this contractor for work. And so I ask in discovery, when and to whom? What conversations are you referring to where you're saying this improper solicitation occurred? And I get nothing. And so if the answer really is, and I'm sure this does happen all the time before your court, if the answer is we think something bad happened, but we won't know until we're done with discovery, that's why the request to admit are included. Because I think the answer right now is we don't have evidence, we think we're going to find it. But if that's the answer, then what I want is I want it under oath that this, to this date, this is every example we know of that would constitute facts giving rise to our cause of action. If they find more in discovery, which they won't, they can supplement. And then when that discovery period is over, we'll be ready for a motion.
Okay, thank you. Mr. Fafarik, what's your position?
I concur with everything that was just said.
Okay, thank you. Mr. Bradbury, anything else?
Yeah, just briefly, Your Honor, because I won't reiterate the things that we wrote in response to the motion. But I think the context of the case, and especially the context of, at least my understanding of the parties trying to resolve the case while discovery was ongoing, is important. So my understanding, again, was that the parties conducted some written discovery in advance of mediation, I assume, on both sides in order to gather some facts and some information which would inform their positions leading into mediation. Mediation, of course, hasn't resulted in a settlement of the case. And so then it was, you know, from plaintiff's perspective, all right, well, investigation phase 2 now, I guess, is underway because we were not able to resolve the case after that round of initial discovery. And that's where we are, Your Honor. So again, the context of the situation, I don't think, is one in which we were truly at the end of discovery. We were nearing the end of the initial discovery cutoff that the court set, but I don't think there was much question, at least in the plaintiff's mind, that what was intended on both sides all along was to extend discovery beyond mediation if necessary, and with the court's permission, in order to conduct more substantive discovery, written discovery, and depositions.
Okay.
Judge,
Well, go ahead.
That simply is not accurate. There was never any such understanding or agreement. We had a court order that set forth the parameters of this case and discovery. And as I mentioned last week, we had served discovery early on, and it took 60 days or better for them to respond to it. It wasn't because we were trying to just limit certain things and obtain limited amount of information prior to conducting a mediation. And there was no discussion at the time of mediation of extending discovery any further. We were working under the presumption, the understanding that this case was going to trial here shortly. So there wasn't any deliberate effort to limit our efforts of trying to understand what was being pled in this case whatsoever.
Okay. Well, what the court's going to do, and the court does recall the motion last week where we did extend the discovery. What the court's going to order is that the plaintiff would respond completely to all of the discovery requests in accordance with the Michigan court rules within 14 days of today's date. If they fail to do so, the defendants can proceed with their summary disposition motions that they'd referenced last week. And then at that time, based upon the summary disposition motions, the court will decide whether the responses and that were sufficient at that time, because on a motion day, I don't have time to go through all of the, again, interrogatories, requests for production of documents, or requests for admissions, but we will have to obviously decide that at the time of summary disposition if that's the appropriate action. So, Ms. Hansman, you can prepare an order and submit under 7-day notice.
I will do that. Thank you, Your Honor.
Okay, thank you.
Have a great day.
Thank you.
What now? What fucking now? Also, I'm pleading the fifth on sharing my dark triad scores.
Good morning, Your Honor.
Good morning.
Good morning.
Please unmute.
Good morning, Judge. Sorry, I'm trying to figure out my camera.
Calling case 2024-1304 CB, Flores Von Reet LLC versus Evolutions Holdings LLC et al. Today is Monday, July 1st, 2024 at 10:15 a.m.
This matter is before the court on the plaintiff's renewed motion for appointment of receiver. I note that plaintiff, you had attached an order in this matter as, I guess, attachment 1 or exhibit 1, and asked to enter that proposed order. However, that order simply states if the defendant fails to make the payment, plaintiff can renew its motion for appointment. So I don't think you want to do that at this point.
Probably not, Your Honor.
Okay.
Probably.
So if the attorneys, as they speak, if they would identify themselves and the parties they're here on, we'll start with the plaintiff and you can proceed.
Thank you, Your Honor. Ben Sobchak on behalf of plaintiff Polaris Fund REIT P73567.
Ron Ryan on behalf of Evolutions Holding LLC.
Okay.
If I may, I think there was a substitution of counsel put forth by defendants. So who's representing the rest of the defendants today?
Yeah, we had a Miss Carr who had appeared. She dropped off. Now she's back apparently. Miss Carr, and
Good morning.
Who are you representing?
Good morning, Judge. This is actually Attorney Caitlin Elias on behalf of Polaris plaintiff.
And to be clear, I do represent all the defendants here.
Oh, okay.
So, yeah.
Okay.
Just when we get all the attorneys involved, I don't know who they're representing.
Right, right.
Okay. Shall I proceed, Your Honor?
Yes, go ahead.
Okay. While I'm obviously a little partial, I think the proper outcome here is obvious, especially in light of defendant's response filed Friday. In our renewed motion, we provided Your Honor with several bases to enter the order, which you pointed out needs to be modified because there's some latent language from the first turn, which we can get taken care of. Starting with the first reason, the prior stipulated order. Polaris received no dollars, not a single one, in the 30-day time frame that the court allowed. Evolutions has been in default here from, about 12 months now. And even though at our status conference, it was represented that they were on track to make the payment, not a single dollar was received. What did happen in those 30 days, though, is that the defendants spent a ton of legal fees on activity in this case and caused Polaris to do the same. Most of that activity has now been countered or conflicts with some of the representations in the response to this motion.
I think this is the pot case, you guys. We listened to part of this maybe a month ago. I am very, very, very said that the company advertised their new grow room and their new XYZ for Michigan, I'm pretty sure. Yeah. That's a case in Texas. This is in Michigan.
Resources should have been directed towards following the order, not questionable litigation tactics. Moving on to the contracts, which I know Your Honor was very focused on in the first hearing. So we're going to build that out for you a bit more. The defendants here have consented to the receivership remedy 10 times in 10 different agreements since the beginning of our business relationship, Polaris and them, I should say. They've also waived all defenses to that result or remedy 4 times in 2 different contracts, the last of which was specifically signed off upon by Mr. Ronald Ryan, opposing counsel, and his email to that effect is attached as Exhibit 5 to the motion, where he writes, "I have reviewed the Second Amendment and have no proposed changes. That Second Amendment confirmed all the prior promises and remedies and the waivers and releases. Polaris would not have continued to do business with these folks at that time, but for those contractual promises and waivers, which we are currently relying upon." The response doesn't really question any of that. Instead, it just says it thinks, defendants think that receivership's the wrong remedy. Noted, but that's not really the defendant's choice at this point. What is important in the response at page 3, I believe, is that they write, Evolutions would like to repay Polaris. This is critical because remember, I have answers that are spackled with affirmative defenses that these agreements are somehow not enforceable. I have counterclaims arguing that these agreements are not enforceable. And yet here today, Evolutions would really like to repay us. So I think that judicial admission probably takes care of the affirmative defenses and several of the counterclaims, but that's not going to mean that we don't all have to continue to spend money and time to wade through that. Instead, the response essentially asks the court to allow Evolutions to unilaterally reset its own interest rate, stay all the claims in this case indefinitely while it decides how it wants to work out the quiet title action, and then allow them yet another 6 months to refi. I would draw the court's attention on page 9 of the brief to the Maple Creek Gardens case, Eastern District of Michigan, 2010, where the court said the contractual receivership right is sufficient and there is, quote, little hardship in enforcing the terms of the party's bargain. To be clear, the party's bargain did not contemplate that the loan's repayment or maturity was contingent on Evolution's ability to refi. I personally would not take a loan with a balloon payment if I only thought that I would be able to repay it by refining with some other third party in the future. Not a smart business choice. If that's where they are at this point, that was their prerogative. In the answer and counterclaims, defendants have disavowed all the contracts. Mr. Flocken has essentially admitted to defrauding Polaris with regard to his pledge equity collateral. My client doesn't want to do business with these folks anymore, right? There's no more deals. There's no more extensions. Like, we have an agreement. We have our rights. They've been in default. They've had a chance. Your Honor equitably gave them another 30 days. It's time to get someone else objective in control. A deal is a deal. The Big Sky case we cite at the motion in 12, agreed upon the receivership remedy and waived. And so a default equals receivership without the consent of defendants. That's pretty much it. The statute, specifically the Michigan Receivership Act, at Section 6, specifically supports this remedy under the contractual situation I've just summarized. That Section 6 also allows the court to appoint a receiver in the event of waste. I talked a little bit about the quiet title action before. I know Your Honor wasn't enchanted with that concept, so I'll just touch it briefly. But note that forgery motion is still before the judge in that case and is expecting a written opinion off a hearing from June 26th, which is still pretty scary. In addition, as I summarized, defendants are spending a ton of money on legal fees, raising, unfruitful affirmative defenses and counterclaims that they've now said the contrary in their own response. But everyone's spending a ton of money on this, when those resources should be going towards the receiver's efforts to gather all this and pull it together and see what's best for everybody. We have no interest payment. Evolutions is clearly insolvent. At some point in the prior motion, they admitted that they're improving their facility without Polaris's consent, which is another violation of the contracts. And in discovery, I asked them how they're paying for those new improvements, and they refused to answer. So I would presume that that's a bad answer and probably more waste. Finally, we have Mr. Flocken's fraud. They've admitted in discovery that he did not have the equity that he pledged to us repeatedly and that we relied upon repeatedly, which is material and just another type of waste, dissipation, impairment, so on and so forth. These folks can't be trusted, at least from Polaris's perspective, and it wants to use its right to appoint a receiver. So I think the concept of waste under the Receivership Act gives the court another basis. In the response, they write that Mr. Flocken's fraud is not the type of waste. I don't know how to respond to that, but I do think that that statement kind of confirms further that the Flocken thing is a real issue, which is questionable as to that sort of a type of admission, but I'll take it. And then let's talk equity. So contrary to a lot of the soft representations in the response, the appointment of the receiver doesn't waive claims per se. If the receiver thinks there's a defense, the receiver is obligated to try that defense. And Polaris noted in its motion that it's happy to do that in a civilized fashion. The receiver has no.
So what's happening in this case, Vince, is that the two companies entered into a contract, one of them lending the other. The company that borrowed the money is having a hard time paying back the money, according to Made. And the lawyer that's talking right now is a joke. Well, I'm answering already. Receiver allocating funds, etc. But very expensive to get a receiver. I do believe it's a pot company though, which adds a little bit of interest to it. But it's I find it's contract law. I mentioned, so I'm going to be intrigued to see what they do this time. Up the screen, it doesn't work with me on it.
Have him maintain operations with necessary employees and try to move this thing along as a going concern for the benefit of everybody. If Polaris wanted to, quote, shutter the business, we would use our foreclosure right. I have a personal property lien on everything there, and I could UCC sell that all and shut down the whole business irrespective of the real property issue. That's not what we are trying to do. It's best for everyone at this point that an objective seasoned business person get in there to assess the business, the quiet title action, this litigation. Cause the court. I really respected the 30 days to pay the interest decision. I haven't seen something like that before, and I thought very thoughtful. And I'll yield to Mr. Ryan.
Okay, thank you.
Yeah, you know, Paul, we started out good, or no, we started out terrible. Then we got good for a little while. Then we got shitty. Nobody's using any of the internet. Everything's
I have nothing further, Judge.
Okay. Okay, thank you. Mr. Ryan,
Your Honor, this is a construction loan with a reef in place. At that time, these parties were talking about doing that mortgage before the wheels fell off the bus. So it was a construction loan. It's not like there's monthly payments that are willingly not being made or voluntarily not being made. The problem here is that there is a cloud in the title, and Evolutions, at its own expense, without assistance from Polaris, has engaged myself, my firm, in pursuit of that quiet title action to obtain to settle the title, and then we can obtain the financing that Polaris is owed in order to resolve this matter. That's why my argument is that a receiver is appointment of receiver fixes no problem at this point. They still don't have title settled in one party's favor or another. The quiet title action is before the Calhoun County Circuit Court. It is scheduled for its last deposition is July 10th. In 10 days. Mediation is on July 17th, and discovery closes July 19th. Unfortunately, we do not yet have a trial date, but we do have the potential of a mediation, perhaps resolution, who knows, this month, within 17 days, if we're able to resolve it. So, you know, what Mr. Sobczak doesn't speak to is the unclean hands argument that I raised here. You know, this is an equitable remedy that they seek, the appointment of a receiver. But they knew when it was actually their title agent that discovered the error in the title, yet they went ahead and closed on this loan anyway. So it's a little disingenuous for them to say that they are somehow harmed. Granted, they're owed the money, but everybody knows that Evolutions doesn't have that type of cash. They never did. They had enough financing and enough investors to make themselves presentable to a mortgage lender and obtain a mortgage loan on this to satisfy the construction loan. But they're part of the problem here. It's not like they're an innocent third party here, Polaris. So although they want the receiver, and this is their third request for a receiver, it's not unlike fixing your wristwatch with a sledgehammer. It really doesn't fix any problem here. Yeah, and even if we were able to obtain quiet title on July 17th due to resolution of the mortgage or quiet title, and we would still need, Evolutions would still need up to 6 months to obtain financing. That doesn't mean they need the full 6 months and they'll obtain financing on that day, but it's not unreasonable to think that under the filing of a quiet title and obtaining clear title, that they would need sufficient time in order to market this thing to banks and other lenders in order to obtain the appropriate financing. So even if we were able to get a quitclaim deed at the mediation, it's not like we can refinance the next day. And then the other comment to make is that, you know, the receiver needs to work. It's not like the receiver is going to be working for Polaris. The receiver needs to be employed and work for the benefit of all creditors. But really what we have here, and I've pointed this out in the brief, we really have a lack of statement as to waste, which would be a need for the receiver. We've got a business that's up and running. It employs up to 40 people. It has engaged in litigation to correct this. It's doing all the things it needs to be doing. There's no allegation that it's squandering the asset or that it's ruining the asset or wasting the asset to the detriment of Polaris, which would be a justification for a receiver. So for those reasons, I do request that the appointment of receiver be denied here for the third time. Thank you.
Okay, thank you. Well, in this matter, obviously there are a lot of issues brought up by the defendants, but the one issue that they're not bringing up and they acknowledge is that they're not making payments in this particular matter. Again, court did previously, when we were in court, did provide an additional 30 days so that the defendants could get into compliance so that they would have the opportunity to continue to operate the business. And that's not happened. Not only has it not happened, they've not even attempted to make any payments in this matter during that particular time, nor have they stated today that they have any intention or any ability to make any payments in this particular matter. So the court does note there's a lot of issues. Obviously, those issues will be ferreted out as we proceed, but under the terms of the contracts, there is a contractual provision that provides the plaintiff with the opportunity to have a receiver appointed to avoid dissipation of what assets or waste. And also in this matter, court would look at the fact that they're substantially delinquent in making payments in this matter. And even when the court gave them an opportunity to, they did not cure it and bring the matter current. As a result, and pursuant to Section 6 of the Receivership Act, court does believe that the receiver is appropriate. the court would grant the motion for appointment of a receiver in this matter. The court will obviously have some conditions. The receiver cannot close nor sell the business without further order of the court. And the court would order that the receiver would proceed with and continue the quiet title action as well, so that that matter proceeds in, again, during the pendency of this action. Obviously, there are numerous other provisions in that the court usually provides in a receivership order, and I can't delineate all of those now. I'm sure Mr. Sobczak, you probably had receiver appointed and know how lengthy those are. And what the court will do is, again, order that relief and that you submit an order for appointment of receiver under the notice of entry of the order, 7-day notice of entry in this particular matter. And anything else, Mr. Sobczak?
Yes, if I may, thank you, Your Honor. Initially, we appreciate the ruling. Firstly, we'll clean up the order. I frankly can't find the part that you mentioned, although it might be latent from the first draft. It is a lengthy document, so we'll give it another run through under the 7-day. I would note, statutorily or under Rule 2.604B, there is a time to object to the receiver himself, Mr. Bullock. We tried to shorten that to 3 days because I think there's good cause for it here. Can that 3 days run concurrently with the 7-day order? Because obviously it's important to us to get the receiver in place as quickly as possible. We have a holiday. I don't know if Mr. Ryan
have it be 7 days and run concurrent with the 7-day notice.
Got it. We'll do that. Next, I just would like to point out, there's these counterclaims, there's this answer. I think that they're essentially stepped on top of by some of the statements made by counsel today. Our response to the counterclaims is due on Wednesday. Would it be possible to stay those dates until the receiver is in place to evaluate the counterclaims, the answer, so on and so forth? Otherwise, we're just going to continue to file things based on, the prior guidance of defendant's leadership.
Mr. Ryan, do you have any problem with extending the dates for response to the counterclaim?
I don't have any objection to that. I do have another issue I want to raise, but
okay. Well, we'll get to you.
In the order,
why don't you put in the order that the receiver would have from the date of the order would have an additional 28 days to respond.
Right. So just for the court's clarity, for instance, the counterclaims would be the receivers. So it would be 28 days for, I'd like, frankly, I want to know if the receiver wants to pull the counterclaims or modify them or whatever before I try to move to dismiss them, just for judicial efficiency, et cetera, because I don't think they're meritorious. And I think given that they said they owe us the money, well, most of them are.
I'm not going to pass on that today.
Understood.
28 days to again respond to those.
Understand. And then lastly, I just want to point out that the stay, including here, only applies to the entity defendants. And so we have personal claims against Mr. Lavender and Mr. Flocken, including fraud. As written, they still have to file their answer to my First Amendment complaint timely. And I want to make sure it's clear that we're not using company resources anymore for that legal representation.
That's fine. And obviously they're independent parties. So we haven't granted a receiver as to those independent individuals.
That's correct. That's all I had. Mr. Ryan, please.
Okay, Mr. Ryan, what did you want to bring to the court's attention?
The court may know that I filed a motion for summary disposition seeking the relief of arbitration, and that hearing has been scheduled before you for July 17th. So that is an issue that we should discuss now.
Okay.
Yeah, I believe that would fall under the 28 days. The motion's not meritorious. The receivers, the arbitration contract specifically exempts claims for us to enforce our security interests. We'll file a motion or a response, but I think it would be better suited to let the objective receiver evaluate those papers before we spend more legal fees on it.
Why we do this is put in the order, Mr. Sobchak, that we're going to extend the date on that to the 28 days as well to respond to the motion for summary disposition.
Yes,
And then Mr. Ryan can, at that time, your response, then he can notice that up if he chooses to do so after the 28 days.
So
the receiver can notice it up. Yes, that's right. Okay.
Yeah, we won't go ahead with that then, Mr. Ryan, on the 17th.
Right.
Got it.
Okay. Ms. Elias, anything else that you have?
Nothing further, Judge. Thank you.
Okay, thank you. Well, get it submitted and we'll get it entered and proceed.
Straight away, Your Honor. Thanks
Okay,
very much.
have a good day.
Back to Wordle. Back to Wordle. Don't worry. Her annoying voice will be right here soon. Can you unmute, please?
You have Niels on this?
Yes, I'm checking in with you.
Okay.
Please unmute.
All right.
All right, iPhone.
iPhone,
First and last name,
Samsung.
please.
Dylan Hall.
All right, Dylan. Let me.
10:30.
I'm in the wrong courtroom, I believe.
Okay.
No, I think we're in the right courtroom.
Yeah, I
Oh.
think we're in the rat courtroom.
All right,
think
just letting you
supposed
know,
to
we do have 5 hearings scheduled at 10:30. I'm gonna place you in the waiting room. I'll bring you in as soon as we're ready to call your case, okay? Do not.
Thank you.
disconnect. Hold on, Samsung, I need to check you in.
Oh, okay.
Okay, your first and last name, please?
Casey Keach.
Let me see. All right. Yes. So Casey, just letting you know, we do have 5 hearings scheduled. So I'm gonna put you in the waiting room and I will bring you in as soon as we're ready to call your case. Please do not disconnect.
Okay, thank you very much.
First and last name, please.
Keith Welcher.
Okay, Keith, I'm gonna place you in the waiting room. I'll bring you in once we're ready to call your case. Please do not disconnect.
I have a question.
Yes.
Do you know how long? Because I'm at work and I'm only on my lunch break.
Josh, you want me to bring, I have that.
So I'm gonna have to just.
You have the plaintiff too?
Yes.
Well, we'll bring him in now.
All right.
Thank you, ma'am.
Yep. Marshall, I'm gonna place you in the waiting room. It'll be just a few minutes, okay?
Okay.
Casey's up, ladies and gentlemen. Here we fucking
Calling
go.
case 2016-1070 DM Keith Welcher versus Casey Welcher. Today is Monday, July 1st, 2024 at 10:41 a.m.
Court will note that this matter is before the court on the defendant's motion to set aside referee recommendation in this matter. So the defendant, go ahead, you can proceed. I have read your motion, so you don't need to reiterate all that.
Okay, I was just, I don't really agree with how much child support he's wanting. I'm not working right now. And I do have medical problems, as my doctor has stated, and I am working with a cardiologist right now. I actually have they're calling me later on today to do a heart monitor. So those are things I'm going through right now. I also have never mind.
No when we all the excuses that people are on the list. And what did she just say? Medals, and he wants too much money. And go on, go on.
That your motion that the doctor had wrote a letter saying about your medical condition, but there was nothing stated in that in the letter as to, again, a diagnosis or prognosis as to your inability to work. And so a doctor can say anything, I'm treating the person for this condition or that condition, but if it doesn't go to the person's ability to work, we in the courts and the referee as a lay individual, we can't assume just because the person's under the treatment of a doctor that they're not able to work. So I don't know. I do note, Ms. Welcher, that you had ordered a transcript and there was an excerpt attached, page 3 of that was attached, but unfortunately, page 3 didn't tell me anything. So what you're going to have to do is, if you want the court to review the entire transcript, you're going to have to provide that to the court for the court to be able to review that.
When I went up to the courthouse, that's all they gave me, is what I sent to you.
I have no idea what they gave you, but again, a transcript of a hearing is more than one page. I can guarantee you that. So we need an entire transcript. And so what happens, the order will remain in place until further order of the court. And if you provide a transcript and the transcript would delineate that the referee made a factual or legal error, then the court will consider resetting the matter for a hearing. Otherwise, the order will remain in place.
Okay, when I sent it in, I got 4 pages that I sent in. I sent it to Mr. Welcher, you guys, and myself, and it is the full transcript is 4 pages.
Okay, all I can tell you is what the court did. I had 1 page.
I never got it.
And it was page 3, and that was it. So
It's with the whole packet.
you're gonna have to, well, you say that, I don't know how it got docketed or whatever. The court did not, I did not receive it. The clerk's office might have received it. I didn't receive it. Mr. Welcher says he didn't receive it. So you're gonna have to refile that so that we do receive it. And again, then once we have the entire transcript, the court can review that.
Okay.
I got a question.
Go ahead.
Do you know when all this is supposed to start by chance? Like when she starts paying or when this goes into
Well,
effect?
it would start, if you look at the order that the referee did, it tells where the order states the amount. Right up above that, it says effective date. That's the date it starts.
Sir, I didn't get it. That's why I'm asking you. I never got any paper, and then I called down there and the lady said that there was nothing in the computer.
You're
So
gonna
I
have
don't
to
know.
take that up with the clerk's office. We don't handle the files for the court. The clerk's office does, and I don't know what's in there or what isn't
I
in there.
figured you
So
have a date on your paper in front of you that says when it's supposed to start.
I don't have it in front of me.
Oh, okay.
So you're
All
gonna have to get that, but it would state whatever the referee's order, the Uniform Child Support Order has an effective date on it as to when it's supposed to start.
Okay.
Okay, that will be the order of the court, and refile that, Ms. Welcher, and court will review it at that time and determine if there's any basis. Okay?
All right. Yes, I will.
Thank you.
I'll call up there. Thank you.
Yes. Please unmute. Marshall, please unmute. Calling case 2023-37 DP Marshall Moore versus Zandon Taylor. Today is Monday, July 1st, 2024 at 10:47 a.m.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court's office. This matter is before the court on the defendant's objection to the referee order. I note, Mr. Taylor and I reviewed the uniform child support order that was entered back on 6/6/24, that consolidated various cases and ordered a child support review in this matter. I guess, is that your understanding, Mr. Magnuson, that there's a review that's pending in this case?
That is my understanding, Your Honor, and I believe that should take care of any issues that are before the court at this time.
Well, that's what the court thought. So, Mr. Taylor, what I'm going to do is I'm going to allow the support review to continue. And I hope that that will resolve all issues concerning support. If it doesn't, you can file an objection or a motion at that time to whatever the referee decides, okay? I think it's premature for us to step in when the referee is doing a review.
Right. Okay. All right. I appreciate that, sir. Will I be receiving any mail about that?
You should. If you keep your address, current address on file with the front of the court, you'll get it.
Okay. Appreciate it.
Ms. Moore, is there anything that you have?
No, sir.
Okay.
As long as he gets that taken care of.
Hopefully that takes care of it and we get it resolved. If not, then Mr. Taylor, you can bring the matter back before the court at that time.
I appreciate it, Your Honor.
Okay. Thank you.
All right.
Have a good day.
Thank you, Your Honor.
Niels, are you appearing on any other motions this morning?
No, I don't have anything else on my schedule.
All right, thank you.
Thank you.
Pepsi versus Meats.
Please. Okay.
Please unmute Caitlin.
What is with the angles, you guys? How did they? Where is his phone? Where is it?
Good morning.
Michael, can you hear me? Please unmute. Oh, can you hear me?
I can.
All right, calling case 2024-10690 as Caitlin Apsey versus Michael Meese II. Today is Monday, July 1st, 2024 at 10:50 a.m.
This matter is before the court on the plaintiff's motion to set aside referee order. Ms. Apsey, I do note that obviously it's clear in your motion, you missed the hearing.
I did.
As a result, did not have any input, but notwithstanding that, what factual or legal error do you believe that the referee made at that particular hearing?
So I was more based off of our custody agreement because I wasn't able to state that I had Michael as much as I do have him, because I have him Monday through Saturday throughout the day because his dad works first and I wasn't able to state that I work seconds. So I'm not able to have him at night. Otherwise, I would be taking him more nights.
Okay. Well, at this point, I will tell you that the child support formula doesn't take into consideration times that you have during the day. It only pertains to overnight parenting time. So that in and of itself is not a sufficient basis to object. And so I don't see anything that you've provided today, nor in the motion, that would change the referee's determination, unless you have something else
I did have something else I wanted to bring into the fact as well. I had just noticed on one of the papers that it had said that Michael was getting unemployment insurance or unemployment pay, the $5,000 per year, when he had stated to me that he had made 80,000 a year. And if he only made 5,000 a month last year, that would imply that he made a $60,000 total sum for the year.
Well,
So-
we don't take that implies or inference or whatever, it's facts. And you have to establish by facts, not by what you surmise or by conjecture. So the court can't take that into consideration just because you think it may be applicable. You know,
All right,
at the time of the hearings, you have a right to bring up all your evidence and that at that time, and the referee considers it. Obviously,
Right.
the referee didn't consider any of that because you weren't at the hearing to bring that up. So it's not
Yeah, I
the
was accidentally
referee's
in the
fault.
wrong room. I was in this room instead of the referee's room by mistake last time.
Yeah. Okay.
So, in that sense, I was wanting to bring up the custody and the fact that I had tried to ask Michael for more overnights and do a 50-50 state, and he said that that wouldn't work for him.
Okay, well, regardless, custody is not an issue today. The issue today was the support amount. If you have a sufficient basis to proceed on custody, you can file a motion and the court would then consider it at that time. But again, that's not before the court today.
Okay, and then with the state of my employment, because I had mentioned that on there as too, as my unemployment or my employment was up in the air. I am currently unemployed, so that was my only other problem with missing that last hearing.
Okay, well, you're gonna have to file, if that's the case and that's occurred since the hearing, you'll have to file a motion and address it, because again, pursuant to again, the opportunity to due process, that the defendant then would have an opportunity to respond, and then we could potentially have a hearing if necessary. But again, you can't bring these up at this time.
Right,
When the other side has no notice of what you're bringing up. So the court's going to deny your request to set aside the referee at this time, subject to, if you want to file additional motions, you can file that.
Okay,
Okay?
Yep.
Thank you both. You're free to go. Have a good day.
thank you.
Next case is Snyder versus Hillman. Plaintiff and defendant are both present. Please unmute.
Hold on. Did he just go live? I'm just checking Chase to send us all over to watch together. It still sucks every time I talk. Okay, give me a second. I'm gonna redirect. Give me a second. Give me a second, please, and thank you. Channel together, and I will redirect us there. But give me one moment to do it. That's all it takes. Doopity potato. It's working like shite. Stay tuned. We'll all get redirected to the next. I think we will, yeah, to the next video.